President. Please be seated. The court is in session. The floor is given through the OCP.
Good afternoon, Your Honors. We will try to respond to the arguments that the defense has made this afternoon, and also later to address some issues that were raised yesterday. I would like to start with the most recent submissions by defense counsel in her oral argument regarding recharacterization of the offense. Counsel states that this would introduce a new element into the trial were Your Honors to utilize joint criminal enterprise for the 4 crimes where the trial chamber did not enter convictions under joint criminal enterprise. She's told us repeatedly it would introduce a new element, but the Q Sampan defense has never identified what is the new element. Is it the fact that there was a plurality of persons who had the intent to commit crimes within the jurisdiction of this court? No. That, we know, was litigated extensively at trial and is found in the judgment. Was it that the accused, Q Sampan, had the intent, or Nunchia, the intent that these crimes be committed? No. That was alleged in the closing order. That was found in the judgment. I will come in a moment to question number 4, what the word intent means. Is it the fact that these crimes happened, that people were disappeared without providing information to their families, that exterminations occurred during the first forced transfer and the second, and that that Lon Nol officials and officers, soldiers, were persecuted by the regime at Tulpotre? No, all of this has been litigated, and the trial chamber has made findings on all of these issues. All of these points the defense had every opportunity and took every opportunity to litigate. This case is exactly very much along the lines of the Stockage appeal judgment that counsel mentioned. In the Stockage appeal judgment, to be clear, what happened in that case is that the trial chamber, civil law judges it happened to be, did not like the concept of joint criminal enterprise, and introduced in the judgment of that trial a mode of liability of co-perpetration, largely following the German model of Roxin and this concept of co-perpetration. Neither party, neither the prosecution nor Stockage, appealed whether or not co-perpetration was a mode of liability at the ICTY. It was the appeals chamber that on its own asked the parties to address that question and then made its own finding that co-perpetration was not within the modes of liability from the statute of the ICTY, and then reanalyzed the findings of the trial chamber to find that all of the elements of joint criminal enterprise were met. So this is a case where the trial chamber made no findings about a joint criminal enterprise. But the factual findings that they did make about how, in this case, the mayor of the town, Stockage, worked together with the police, with the army, in a criminal enterprise to forcibly deport individuals from the municipality, resulting in mass crimes and approximately 1,500 killings. All of these, they found, fit the elements of joint criminal enterprise and convicted him of various crimes under joint criminal enterprise. Now, the concept of joint criminal enterprise and how it's used in this case, I think, has been complicated, frankly, in the defense argument. And I'd like to revisit it a bit in a somewhat simplified form. First, absolutely the defense is correct. Joint criminal enterprise, of course, requires that the objective or the means of those entering into the agreement, that they have contemplate a crime within the statute of the tribunal. And in this case, to simplify both the closing order and the findings of the chamber, what's clear is they said that there was a non-criminal ultimate objective, and that was this radical agrarian revolution, and that the members of the joint criminal enterprise, including, of course, Nun Chia and Khieu Samphan, the other top leaders, agreed, understood that they would use criminal means, crimes within the jurisdiction of this court, to accomplish that objective. Now, I'm simplifying it a bit because I'm taking out this intermediate step that the closing order put in and was followed by the trial chamber of the 5 policies, which examined all of this in more detail. But to simplify it, and it's absolutely clear, this is what the joint criminal enterprise boils down to: an intent to achieve a radical revolution, political revolution, not in itself a violation of international criminal law, but by means that were clearly criminal. And the evidence in this case and the findings of the trial chamber have shown that each of the accused made significant contributions to that enterprise. And I could go into that in some detail, but just very briefly in regards to Khieu Samphan, what the trial chamber found is, in his own words, he played an important, if not essential, role in the Khmer Rouge development of their policies. He served, as you know, in various positions that made him very prominent in the public, both to the Cambodian public and internationally. And this was in a regime where it was very secretive, so that amplified the importance of his role. He was seen by many people as the leader of the Khmer Rouge, because that's all they knew. Pol Pot and Nun Chia were staying in the shadows. And the trial chamber, the evidence shows and the findings show, Khieu Samphan made very important contributions to that enterprise, in particular to these killings, both in his further announcements that the 7 traitors would be killed, and I think he added some names, including Lon Non, who was killed, to those who would be killed, with the threat that anyone who didn't join them in time would further suffer the same fate. Those who didn't defect before the victory of the Khmer Rouge would suffer the same fate. And in announcing many of the announcements he made during the evacuation, he was the person that was on the radio talking about when Lon Nol, for example, fled, when the Americans pulled out. He was the person that was on the radio representing the Khmer Rouge. And when people were on the road being evacuated from Phnom Penh under horrendous conditions, inhumane conditions, Khieu Samphan remained the spokesperson, the voice, justifying this, glorifying the great victory of the Khmer Rouge in capturing Phnom Penh, all the time that what the regime that he was serving was inflicting this tremendous suffering upon the population. So the findings of the chamber clearly show that both Nun Chia and Khieu Samphan made their significant contributions to this joint criminal enterprise, which clearly contemplated the use of criminal means to achieve their objective. Now I'd like to come to the question that Your Honors asked about intent. We all agree that the cases have said that those who are members of the joint criminal enterprise under the first form, the basic form of joint criminal enterprise, in fact, for all forms, but also for the third form of joint criminal enterprise, must intend to commit a crime within the jurisdiction of the court. The question is, what does the word intend mean? And we submit that if you look at general principles of criminal law across all legal systems, the word intent is never, for general intent crimes, I'm not talking about specific intent crimes like genocide, but for general intent crimes, the word intent always includes committing intentional conduct with knowledge of the consequences that will occur or probably will occur. I'm hesitating because you see across different systems, different words used to express the concept that the person commits the intentional conduct aware of the probability, the substantial likelihood, the fact that it will occur in the normal course of events, that it's natural and foreseeable. All these different words are used to express what it means to intend a crime. And in civil law, it's generally, the general approach is to divide intent into three concepts. First, dolus directus of the first degree, that this is the object of your conduct. The object of your conduct is to kill this person. Second, dolus directus of the second degree, which we submit at a minimum is included in the joint criminal enterprise of the first degree, joint criminal enterprise in meaning of intent. Dolus directus of the second degree, expressed again in different systems, in different countries, in different languages, in slightly different words. But it means that you're aware that this consequence is probable, substantial likelihood, natural and foreseeable, will occur in the ordinary course of events. Different words are used for that. But it expresses the concept that you're aware that your conduct has a, I'll use the word substantial likelihood of causing this consequence. And in fact, we think the word substantial likelihood is the most appropriate. It's, remember, the joint criminal enterprise in the tribunals, including this one, ICTY and ICTR, has been found by your honors in different court, or by the pre-trial chamber here, trial chamber here, appeals chambers and other tribunals, to come under the statutes of those courts because it's part of committing. They say the word committing includes commission by joint criminal enterprise. So what is the intent required for committing? Well, again, it's been expressed slightly differently in different cases, even at the ICTY, but in Lukic versus Lukic, for example, the trial chamber held that, quote, this is paragraph 900, that the requisite mens rea for committing is that the accused acted with the intent to commit the crime or with an awareness of the probability in the sense of the substantial likelihood that the crime would occur as a consequence of his conduct. To give a very practical example, a person is trying to get away from the police and the traffic is slow in front of them, so they decide to go on the sidewalk to go faster, to get away from the police, knowing that there are people, or likely to be people, on the sidewalk. I think in any legal system where the person does that, even though they may hope, gee, I hope I don't hit anyone because it'll slow me down. Their objective is to get away from the police, not to hit people. But they're aware by driving on this sidewalk, there's a substantial likelihood that they're going to hit and kill pedestrians. I think in every legal system, a person would be held responsible for that conduct. Now, one of the things that I felt the defense was conflating continually this afternoon, and also in their appeal brief, is the mens rea for joint criminal enterprise of the extended form, JC3, with joint criminal enterprise in the first or even the second categories. Contrary to what the defense is saying, substantial likelihood is not the standard for joint criminal enterprise in the third extended form. Joint criminal enterprise with extended form is very, in my submission, very consistent with what is normally called dolus eventualis in the civil law system. If you look at the Krajišnik decision on this issue, there was a appeal judgment decision, an interlocutory appeal. See if I can find that. I hope I can come back to you with that later. But in that decision, Krajišnik made it clear that, excuse me, I'm sorry, it's Karadzic, it's not Krajišnik, it's the Karadzic decision in the more recent case of Karadzic. The appeals chamber made it clear the defense was challenging whether or not the intent required, mens rea for the third degree, should be that the event, the crime, will probably occur or just possibly occur. And the appeals chamber made clear in Karadzic's decision that the standard is possible, but possible, and the accused must accept that risk, must reconcile himself with the risk. So that is what the extended form, the mens rea for the extended form of joint criminal enterprise amounts to. Now, the evidence in this case we submit and found by the trial chamber clearly shows that the killings, the forced transfers, all of the crimes, the extermination, the persecutions, all occurred in an extended pattern. And the accused had pre-knowledge of these events for many years, for this pattern of conduct, continual knowledge of these crimes occurring, and continued to make their contributions to this joint criminal enterprise. So the evidence in the case we submit shows clearly that they had the intent. They were aware, we would say, of the best words we would say to use for the intent required for the first form of joint criminal enterprise is substantial likelihood. But I don't see that as being different, other than semantically, in practice with cases that use the words knew that in the ordinary course of events the crimes would be or could be committed. Recall, for future events, it's never possible to know with an absolute certainty that events will occur. We can only know that they're probable to various degrees of probability. Even in the Eisengruppen case, this group of mass executioners that killed hundreds of thousands during the Nazi purges of minorities, Jews and other minorities. Yes, counsel read something where she quoted language, where said they participated in it, knowing that crimes would occur. But of course, you never know for certain that, for example, the Allies won't achieve victory the next day and no one else will be killed. You may send a trainload of victims of minorities, of Jews or Roma, to Auschwitz. You don't know if for sure that they won't escape, that the war won't end before they are executed, or that they won't be one of the very few that are picked out to do labor instead of being killed. That hardly would mean that you don't intend their killing by your conduct. You do conduct aware of the substantial likelihood, or that in the normal course of events, these crimes will happen. And this is exactly what happened, what occurred with Khieu Samphan and Nguyen Chia, and the killings at places like Tulpotre. Of course, the trial chamber found they were not aware of every single killing around the country, and there wasn't clear evidence that they knew beforehand about the killing at Tulpotre. But it was part of a pattern of conduct that they endorsed and certainly knew about, and contributed, and part of the joint criminal enterprise that they continued to contribute to. One clarification, I think counsel at one point said you must contribute to the crime in joint criminal enterprise. That's not correct. If you go to Tadic, unlike a mode of liability such as aiding and abetting, where you have to show that the accused's contribution was a substantial effect on the crime, for joint criminal enterprise, you simply have to show that the accused made a substantial contribution to the enterprise. There's many other points to cover, but because time is limited, I also wanted to give an opportunity to my colleague, Mr. Lysick, to address you on some of the issues about the planning for the first force transfer, in particular Q Sampan's role in the planning for the first force transfer, particularly since a lot of emphasis was put in the defense arguments on the testimony of P. Poon, and he is the co-prosecutor who conducted that examination. So I turn it over to him at this point.
Good afternoon, Your Honors. I'm happy to take this opportunity to address what I think is probably the most central issue that has been raised by the defense in what you've heard so far in these appeal hearings. We've heard a lot of rhetoric, accusations that the trial chamber is distorting the evidence, that this was not a real trial, a show trial. What I would like to do with you in the time that I have is show you that this was about the evidence. Q Sampan was not convicted because of some bias that the trial chamber held. Q Sampan was convicted based on very clear evidence of his contribution to a common criminal plan. And specifically, what I want to talk about are the two meetings that counsel, Q Sampan's counsel, made reference to yesterday. The two key meetings at which decisions were made by the Khmer Rouge leaders to evacuate all the residents of Phnom Penh. The first was a meeting that was held in mid-1974, June to July time period. That is the meeting that Noon Chea, at the very start of this trial, described in detail in a statement he gave, and on which he was subsequently examined while he was testifying. It's a meeting that is referenced in some of the revolutionary flags and contemporaneous documents. And Noon Chea describes what took place at that meeting and the initial decision made at that time that when Phnom Penh was captured, the entire population would be evacuated with no exceptions. No exceptions for the sick or elderly. Everyone had to go. The issue that P. Poon brought to this meeting, P. Poon testified that Q Sampan was one of the leaders who was present at that meeting. And this became a central issue of dispute, disputed by the defense and by Q Sampan's wife. Your Honor asked a question yesterday about whether the trial chamber made an effort to address credibility and resolve conflicting evidence. And this is This was a key part of the case where there was conflicting evidence, and the trial chamber needed to do just that. And I want to, before I get back to how the trial chamber resolved that, just to reference you to some jurisprudence from the ICTR on this very issue of what is required of the trial chamber in this type of situation. And this is a case cited in paragraph 95 of our appeal response. Forgive if I mungle the pronunciation of this case. It is the Kajela Jelly Appeal Judgment, ICTR 98-44A-A. And specifically, paragraphs 59 to 61 of that decision contain some very detailed discussion of what is required from a trial chamber in this situation. I quote from paragraph 59. The appeals chamber is mindful of the position expressed in the Mosima appeal judgment that a trial chamber is not required to set out in detail why it accepted or rejected a particular testimony. There then is some discussion of the general law about the task of weighing and assessing credibility of witnesses being with the trial chamber. Your honors have yourselves pronounced law on this in the appeal judgment. I will not take you back to that. Continuing in paragraph 60, while the finding could have been elaborated by discussion of the specific witness JK-27's credibility, the trial chamber's failure to do so falls short of violating the appellant's right to a reasoned opinion, which does not ordinarily demand a detailed analysis of the credibility of particular witnesses. In Mosima, for instance, the appeals chamber held that a trial chamber is not necessarily required even to refer to particular evidence or testimony in its reasoning, much less give specific reasons for discrediting it. Of particular significance, though, is the next paragraph, paragraph 61. Under some circumstances, a reasoned explanation of the trial chamber's assessment of a particular witness's credibility is a crucial component of a reasoned opinion. For instance, where there is a genuine and significant dispute surrounding a witness's credibility and the witness's testimony is truly central to the question whether a particular element is proven. And they give an example of a witness or testimony, identification testimony coming from a single eyewitness. Your honors, that is what the trial chamber did if you look at its judgment in discussing the competing evidence on whether Q Sampan was present or not at the mid-74 Central Committee meeting. And this discussion is in paragraphs 133 through 142 of the judgment, where there is a very detailed discussion of the evidence, assessing the credibility of the respective accounts that were given by P. Pun and by Q Sampan's wife, the evidence that existed that corroborated or did not corroborate, and the conclusions that were ultimately reached as stated in paragraph 139, was that given the contradictions in So Sachit's testimony, her motivation to assist her husband, the clear testimony of P. Pun, and the equally clear information provided by Sun Sukun, the chamber finds that So Sachit's evidence is unreliable. So, your honors, I point this out because the question was raised yesterday, and as we indicated, we do not believe, and we don't believe it was feasible for the trial chamber to assess the credibility of every single person who testified. But where there was key issues, where there was witness testimony in dispute, they did so. And let me talk a little bit now about what was the evidence that led the trial chamber to conclude that Khieu Samphan had in fact been present at this meeting. Specifically, there was a number of pieces of evidence that confirmed and corroborated his account that Mr. Ieng Sary and Mr. Khieu Samphan had returned from a foreign trip for this meeting. Let me say a few things first about who Phipon was, because this was brought up by counsel yesterday. Phipon, at that time, was the personal guard of Pol Pot and Nuon Chea, the very top leaders of the party. He had been introduced to the revolution in 1963, became a member of the Youth League of the party in 67 or 68, and became a full rights member of the party in 1971. That meant that he, as a party member, attended political education meetings. And he testified in this court that the people who instructed him on the principles, the policies, the party lines were none other than Pol Pot, Nuon Chea, Ieng Sary, and Khieu Samphan. This was a significant witness. When the Khmer Rouge came into power, Phipon received an appointment. He was appointed to be the third-ranking cadre at the Ministry of Foreign Affairs. His title was Office Chairman of B5. B5 was the Ministry of Foreign Affairs office. So we are talking about a witness who had a significant basis, significant knowledge, significant contact with the very top leaders of the Khmer Rouge. Something that you could only know from being in this courtroom, and I think that is the difficulty and the reason for the law about credibility of witnesses being a matter for the trier of fact. You would have had to be here for his testimony and the testimony of almost all the others to understand how different Phipon was from many of the other Khmer Rouge cadres who came to testify in this court. He was clear and straightforward. He was direct. Unlike many who came in and were evasive, denied the positions they held in the regime, were evasive in answering questions to the point that you had to drag the information out of them, which we did. He answered the questions. His memory was extremely good. He was a breath of fresh air in this court, and he was extremely credible. And that is why you heard the defense go on the attack against him yesterday when we were to be discussing issues relating to fair trial rights. Why did the trial chamber accept Phipon's testimony about Khieu Samphan being present at that meeting? Because it was corroborated. Because they heard from another witness, Sun Tsukun, who was with Khieu Samphan and Ieng Sary on a trip they were taking abroad, about the timing of their return to Cambodia. Specifically, that they came back to Hanoi at the end of May 1974. They then went down to make a visit to a stop to Laos, to the liberated zone in South Vietnam, and by early or mid-June, Khieu Samphan and Ieng Sary were on their way back into the country. there's an issue that I will not get into right now about some contemporaneous telegrams. If you have questions about that, I'm happy to get into that, but I will leave that aside. But there are also contemporaneous diplomatic cables establishing the timing. Second reason, the testimony of Khieu Samphan's wife. What she ultimately testified, and let me refer your honors specifically to testimony on the 10th of June 2013, which took place at 1423 to 1428 and 1540 to 1516. She testified that their first child was born on the 4th of May, 1974, and that around that time they had to move to the Meek office. It was a new office, and I went there during my early days after giving birth. Then, question, at the time when you had your first baby, was Mr. Khieu Samphan with you, that is, on the day of the delivery of the baby? Answer, during that time when I gave birth to my first child, he was in China, and about a month later, he returned. We remained together and went to the Meek office. End of quote. So, while Soh Sit-chit came here to try to give an alibi to her husband, because she testified that when Khieu Samphan came back from meetings where he was negotiating deals with China and Vietnam to support the Khmer Rouge, she claimed that he then spent 2 months staying at home changing nappies. That is the exact words that she used. Now, the trial chamber did not find this credible. More important about her testimony, though, she puts Khieu Samphan back in Cambodia in June 1974, the time of these meetings, and she puts him at the location where the meetings took place. These meetings took place at Meek. When you look at Soh Sit-chit's testimony, she puts herself and Khieu Samphan at the very location where these meetings took place. I also mentioned Ing Siri made an admission in an interview with Steve Heder that he returned in 1974 to the country and discussed at a meeting with Pol Pot the evacuation. This was also relied on by the trial chamber. I go through this in detail because it has been repeatedly said here that this case has not been decided on the evidence, and that could not be further from the truth. For us, this has always been about the evidence. Everything that went on in this courtroom for almost 2 years, October 2011 till the trial was finished in 2013, was about the evidence. It was very important to us that the evidence be presented accurately, fairly, that the defendants have a chance to confront that evidence, and that the convictions, that the judgment be evaluated and decided based on the evidence. And we take extreme issue with the rhetoric we've heard so far in these hearings. The second meeting, which in some ways is even more important, that Pipon testified to, was a meeting in early April 1975 held at an office called B5. And B5 was the Central Command headquarters of the Khmer Rouge leaders, an office established by Pol Pot, where he met with the military commanders from the various zones and commanded the attack on Phnom Penh. Pipon was there because he, again, was working as Pol Pot's guard. And he testified that a meeting was held about 2 weeks before 17 April to finalize the plans for the evacuation. He described in detail where the meeting took place, the time of day, and he testified that both Nunchea and Q-Samphan were there, that they both expressed their positions, and they both agreed to the plan to evacuate Phnom Penh. Again, the trial chamber looked to see if there was corroborating evidence to support Phipon's testimony, and there was, because both Nunchea and Q-Samphan admitted, have given statements that they were at that location in the weeks preceding 17 April 1975. And indeed, there is actually film footage of Pol Pot, Nunchea, and Q-Samphan together at the very location where this meeting took place at B5, which was identified by Phipon. For your Honor's reference, it's E3/2346R. It's a video at 0140:21 to 0140:34. This is the type of detail that we heard in this courtroom. Final confirmation, a July 1982 interview of Q-Samphan reported by the New York Times, document E3/687. This is what Q-Samphan said to the New York Times in 1982. This is the reporter's words. He, referring to Q-Samphan, acknowledged that millions of Cambodians had been sent out of Phnom Penh and into the countryside as a result of a collective decision. Had he joined in the decision? Question, asked the reporter. Mr. Q-Samphan chuckled dryly and replied in French, yes, evidently. Your Honors, evidence of 2 meetings at which Q-Samphan participated, direct evidence from an eyewitness that Q-Samphan agreed to the plan to evacuate the population of Phnom Penh. This is not a distortion. This is the evidence that was heard in this courtroom. That plan, by the way, we heard the question, what was his contribution to a criminal plan? The plan that Q-Samphan agreed to was criminal in nature. The forced eviction of millions of people from their homes without adequate provision for food, water, shelter, medical care. As Q-Samphan said himself, if there had been a single vote against the evacuations, there could have been no evacuations. That is the collective decision principle that your honors are, I'm sure, are aware of. Your honors, the evidence about Q-Samphan's contribution wasn't just limited to his attending those meetings. Phipon also testified that Q-Samphan was one of the cadres one of the leaders along with Pol Pot and Nunchea, who conducted presentations to the cadres to explain why the evacuation was necessary, and relied on experiences from other cities they had captured, such as at Udong. You'll find that testimony in Phipon's testimony on the 26th of July, 2012, document E1/97.1 at 11:04:31 and at 09:45 through 09:48. So this is the evidence upon which Q-Samphan was convicted. compelling, detailed testimony about his approval and contribution to a criminal plan to forcibly evacuate the population of Phnom Penh, corroborated by multiple sources. Not civil party applications, not victim impact testimony, written records of interviews, testimony of witnesses who appeared in this courtroom and who were cross-examined by the defense. By any accounts, a real and fair trial. Your Honors, I don't know where I am time-wise. I was going to say a few things about the argument that the the Khmer Rouge militaries were not subject to a central command, but yes? Okay. The one other issue I want to talk about today is the issue that Council have raised as to whether the zone, whether the armies were independent, autonomous zone armies, or whether, in fact, they were subject to central authority. You heard some quotes from Philip Short, the expert from both the International Co-Prosecutor and from Khieu Samphan's counsel. But there was much, much more evidence from the people who were directly involved in this, from the people who were at these command headquarters. That is the dispositive evidence, I believe, when we look at this issue. And specifically, we heard from 4 or 5 witnesses about the 2 command headquarters operated by Pol Pot, Nuon Chea, where Pol Pot, Nuon Chea, and Khieu Samphan were based from 1970 to 1975. First S-71 and then B-5. I heard a quote read suggesting that there was problems with communications, but we heard from multiple witnesses who were actually involved in the telegram offices in that time period, the wartime period. Norn Sofang testified on the 29th of August 2012 at 1438 to 1442 that when zones were involved in contentious battles, there were telegrams coming to the CPK, the party leaders at S-71, I quote, 24 hours around the clock. He described how he received his telegram training in '73 and was the chairman of the telegram office at the command headquarters as of 1974. We heard from Pipon about details to the point of the type of radio equipment that was at the command base that allowed direct communications between the leaders and the battlefield. Pipon also testified that while he was at B5, he delivered messages between Khieu Samphan and the battlefield. This is on the 2nd of August 2012 at 9:12 to 9:15. Numerous witnesses testified to the zone commanders coming for regular meetings to obtain instructions. And I would specifically direct your honors, by way of corroboration of what we heard from the witnesses in this court, to an interview that was given by Kai Pak before his death. Kai Pak was, at the time of the war, the deputy secretary of the North Zone. He was one of the military commanders overseeing troops in the war, and he later became the secretary of the Central Zone. His interview is E3/2782, E3/2783, and you will find in that interview a very detailed account of the battles during 1970 to 75 and the orders that he received directly from the Central Committee or Son Sen about where to attack, about the attack where they tried to capture Kampancham provincial town and take the people out of there. There is simply no question on the evidence heard in this courtroom that this was a centrally commanded military operation. Your Honors, I could address you for length about the evidence in these proceedings. All we ask is that when you reach your decision, it's based on the transcripts, the documents, the evidence that we worked very hard to put before the trial chamber for almost 2 years. We simply cannot decide this based on rhetorical arguments that this was a show trial. I'm happy during the time I'm here to answer whatever questions you may have. As someone who was there in the trial, I have a little more familiarity with the record, and I have an understanding too of the difficulty of the task that you have. This is an enormous record, 90 witnesses who testified, thousands of documents. I know how difficult it was for us to put it all together into final submissions, and we are here, as I'm sure the defense is, to answer your questions and do the best we can. But I wanted to address these specific factual questions because I think they're very important to your decision.
I was allowed one question by the President. Counsel, could you, at least in a sketchy form, help us, however, connect the alleged or contentious presence of Khieu Samphan at meetings, which you described, with his knowledge of extermination or murders that occurred during the evacuation of Phnom Penh. We are aware that there is an evidence that in the meeting that is the second meeting that at B5, there was a success of Udong evacuation discussed, but we understand from the evidence of the same witness, it had gone smoothly. So the B5 meeting wouldn't on itself necessarily show that a sinister or more sinister than the evacuation in itself purpose was contemplated in whatever form of intents described by the prosecutor. So if you could at least point us in the direction where would the prosecution like us to look. We are very well aware that the teams on both sides have vast knowledge of case 2 before its severance, and hence your vision of certain attributions is broader, I would say, than ours, which is looking at through the reversed, binoculars. So if you could help with this, I'd appreciate. If not, we will wait with our questions for tomorrow's session.
Thank you, Your Honor. I don't have my notes immediately handy on Udong, and I want to give you specific references, but I can give you a general answer to that question. I wouldn't exactly describe Pipon's testimony as the evacuation of Udong went smoothly, that it was a non-event. By smoothly, he meant it was successful. And so you have to look at the details of what actually took place when Udong was evacuated. And that comes from a number of sources. It comes from some accounts we heard from some witnesses in the court, a witness named Nu Mook, and from some research conducted by Philip Short. It comes from also evidence of what happened in other cities that were captured by the Khmer Rouge. And Steve Heder, I'm reminded also. I will tomorrow have those specific references for you, but it is clear that what happened when major cities were captured by the Khmer Rouge prior to Phnom Penh was criminal in nature. People were not just politely asked to join the Khmer Rouge. I remember the testimony of Francois Panchaud in this courtroom. He lived in Kampong Cham area during that period, so he had firsthand experience of what took place when the Khmer Rouge captured towns. And his testimony was there was a routine practice when they would capture an area. They would take out all the people out, they would kill the commune chiefs, and they would burn the houses. Steve Heder made it to Udong, I think maybe a week, 10 days after the Khmer Rouge had done its damage there. He found bodies of murdered nuns, many other people who had been killed, evidence that things were far from smooth, Your Honor. But I will get those. I want to give you specifics. But in general, it was very clear from the evidence that what took place when the Khmer Rouge captured cities prior to Phnom Penh was horrific. And this was a common practice. It wasn't isolated. The same thing happened every place when they captured it. So I will bring some of that, some specific sites for you tomorrow.
President, thank you very much. It is now a good time for the adjournment. And the chamber will resume its hearing tomorrow at 9 a.m. Security personnel are instructed to bring the two accused back to the detention facility and have them returned tomorrow into the courtroom at 9 a.m. The court is now adjourned.